Welcome to the webinar. You have entered as an organizer and may now speak to any other organizers or panelists on the line. When you are ready to begin the presentation, press the Start Broadcast button on the GoToWebinar control panel to allow all attendees to hear you. This system will notify you once you begin your broadcast. The broadcast is now starting. All attendees are in listen-only mode.
All right, everyone. Thank you for joining us. This is Lindsay Miller with the New York Association on Independent Living. And today's webinar is an overview of the Lobbying Act and JCOPE's new regulations. The intention of today's webinar is to review some of the changes being implemented by New York State with regards to what constitute lobbying activities and the requirements for reporting. As you'll see as we go through the PowerPoint today, all of the content of which we pulled from JCOPE's new training. There are still many questions to be answered, and the devil is certainly in the details. But the intention of today's webinar is really to focus on what activities constitute lobbying and what triggers the requirement for reporting. And I think you'll find as we go through it that many of the ILCs on the line today, and probably all the ILCs in the network, certainly engage in lobbying activities and are likely should be reporting. So this is intended to be the kind of first in a lengthy discussion in terms of helping centers understand the requirements and meet that obligation. So I'm joined here by Kevin Cleary, NYAIL's lobbyist, who's going to be our main presenter and walk us through the slides. We will be taking questions at the end. So I encourage anyone on the line, if you have a question throughout the presentation, to enter them in the questions panel. You can type in your questions and we'll go over them at the end. There will also be an opportunity, I think, for us to open the lines if people have questions. All right, Kevin, I am turning it over to you.
Hi, good afternoon. As Lindsay said, we'll walk through a couple of definitions and basic responsibilities, and I think you may be surprised that a lot of the stuff that you do in the normal course of business in some fashion does constitute and meet a legal definition of lobbying. The question is, if you're lobbying, how much do you have to do before you're under some sort of an obligation to report? So on the next slide is a definition of what lobbying is, and it's fairly broad. State or local legislation. I mean, I don't think NYAIL itself gets involved very much at the county or municipal level, but certainly New York City probably more so than other municipalities. I could be wrong, but in any case, it's state or local legislation or resolutions. Now, state legislation includes budget bills, so that's a fairly broad group of issues that would be the target of trying to influence. Executive orders, a little bit less so, but we have had things like the Olmstead, Employment First, the New York State of Health, which is the New York Health Exchange, was actually created by executive order. So there's a lot of things out there in terms of executive order that a lot of the network would have some interest in and certainly have some comment about. So talking and lobbying about those things would also be. Regulations, again, a smaller subset for some perhaps, but depending on the issue, when the health department or Department for Aging or any of the other state agencies, state education, promulgate regulations that would affect us to the extent that we're lobbying on those regulations, not because of the regulations, but on new, really mostly proposed regulations. We'll get to that. That's also lobbying. Rate-making proceedings, probably not so much. Those of you who are involved in Medicaid may be involved to some extent in rate making. Certainly you would have rates. I think a lot of the rate making is intended to get public authorities and utilities and things like that. Government procurements, certainly NYAIL is involved in procurements. At the local level, you may be procuring stuff at the municipal level or even at the state level, but there's definitions that we'll get to as to how big the procurement has to be and what exactly you're doing. Generally, with a lot of the procurements, you're not really lobbying; you're mostly bidding and and attending bidders conferences, which I don't think meets the definition. The tribal state contracts is really most of that stuff is an attempt to for the state to understand what's going on with the tribes in New York, and a lot of it has to do with gambling. So the definition at the bottom, they group them all together. No one ever calls them the 1cc activities except for this slide, but it is used a few times in the presentation. So any lobbying on any of these things collectively is known as those particular activities. Next slide would be, what's an attempt to influence? And so lobbying in favor of, opposed to, amendments to bills, delaying or expediting, all of that would really be lobbying on those particular issues that we just covered. And a public official, I think we get to the definition later. A public official is really anyone who works for the state and includes legislators and people working for the governor's office, but it also involves people who are state agency employees. Not every activity before a state agency is lobbying, and we'll get to that. I mean, there's a lot of things that through the normal course of business that you're meeting with people about and talking about that really don't have to do with specifically regulations or legislation and things like that, rate making. So all interface with government is not lobbying per se, but certainly a lot of the things that we're interested in and trying to influence people to do would be lobbying. Next slide is, so if you're having meetings, you're making calls, you're emailing position papers, you're distributing stuff, and social media interactions of a variety of sorts, all of that is activities through which you lobby. So it does say not limited to. I can't think of any not limiteds off the top of my head, but certainly on lobby days and through the normal course of business, we're either meeting with people, talking to them on the phone, sending them emails. I don't do a lot of social media interaction myself, but I know there's a lot of that going on as well. So that's the form that the direct lobbying would take. On the next slide, we're talking, they take particular effort to identify grassroots lobbying specifically. That is something that through the SAN and other things that NYAIL does do, and I think we even ask you at the local level to do, which is to get out the word, take a call to action, urge the public or public officials to support particular positions. So it's more specifically in the new regulations identified as specifically lobbying. I think it kind of always was, but they're really trying to call out specific types of activities. And I think this is something, at least from the network standpoint, that you're involved in, at least on an occasional basis. Okay. So all of that being said, we've talked about what lobbying is and how it's done and the forms it takes. And the real issue is, if you do it, do you need to report it to the state? Excuse me. So the two thresholds are, one is that you're doing it, and two, that you would expect to or you do exceed a $5,000 annual threshold. And that's in expenses and compensation. We'll get to that in a little bit more specificity. but it's not 5%, it's $5,000. So for even smaller agencies that have a $400,000 or $500,000 budget, it's possible, might even be likely, that you're already doing $5,000 worth of lobbying without understanding it, knowing about it, and we're bringing it to your attention that at least by state law, you're required to register as a lobbyist if you do that. I don't think that there's any negativity associated with that. Some of the reporting requirements are occasionally annoying and take up a little bit of time, but the real issue is the state does want to know if you're trying to influence government activity that you identify yourself and that you report how much of it you're doing. On the next slide, it talks about calculating it. And again, if you look at the $5,000 threshold, that's certainly if you're paying an outside lobbyist $5,000, you're doing it. If your staff and yourself are doing it based on a percentage of your compensation in the aggregate combined with reportable expenses, it doesn't seem to be too hard to get to $5,000. And so it's, again, it's not required. It's likely in many instances that some of the centers may have to consider registering as a lobbyist for the first time. I know a few centers are doing it already. We'll skip to prohibitions. If you lobby, and generally this isn't even just a lobbying restriction, it's a restriction generally, you can't give gifts to public officials. You can certainly give them to people you're related to who work for the state, but generally there's an overall prohibition on gifts. Again, it extends to local governments over 5,000. So I don't know that there's a lot of, there may be some hamlets that wouldn't fit there, but most local officials would also qualify as public officials and a target of a gift. So a gift is what you would think it is. It's a gift. There are some exceptions on the next slide. Again, they always get into non-exclusive and including but not limited to, but these are probably the same thing. If you give a campaign contribution to a candidate, that's not a gift, that's a campaign contribution. They say food or beverage at $15 or less at an event. So if you're holding an event and an elected official comes and there's a $10 lunch, technically not. Attendance at political events, widely attended. We, from a NYAIL perspective, we do give awards out and plaques. That's probably the primary example here. I know myself as a lobbyist, I try to practice a zero tolerance when it comes to gifts, so I don't give gifts, period. So, because I think there's only trouble associated with them, and when you start recognizing that you may be giving small things that you think are exceptions, I'm not sure that it calls direct attention. But I would just assume when they lowered the limit from $75 to this, I went to zero. So, because again, there is no penalty legally associated with collecting a gift. The penalty is associated with giving the gift. So that also, as someone who was identified, none of us were ever benefiting from any of the gifts, but we were the ones that had to pay the price if there were consequences associated with it. So my general advice to you, and you can ask about it, is to stay away from gifts in any form. Procurement lobbying, certainly NYAIL has participated in a number of procurements. You may as well with local governments and the state, but if you go to the definition, it has to be at least $15,000. And in many cases, you're not lobbying the procurement because you're not influencing the contract. All you're doing is bidding. Bidding for a contract is not lobbying. but there is people get wind of big contracts being let by the health department for the computer systems for the Medicaid program, stuff like that. They do try to get in and influence, if you're IBM or you're another large company, how some of these things might be written so that when the procurements come out, they're a little bit more favorable to your interest than the products that you're selling. So that's the attempt on limiting on procurement lobbying. Again, on the next slide, it continues on procurement lobbying. I mean, the lobbying, the State Procurement Act limits the state agencies and what they can do. Typically, if you're involved in a state procurement, once the procurement is announced, there's a designated contact at the state agency level that you can deal with and nobody else. It is illegal to contact other people who work for the agency to try to influence them beyond the contact period that's typically called, they call it here a restricted period. In Albany, it's pretty much known as the blackout period. And the blackout extends from the point where the procurement is released to the point where it's awarded. Okay. So part of the reason for the for this presentation was the fact that we wanted to bring the attention to a lot of the centers of the fact that the threshold for registering as a lobbyist was might be lower than you thought, but also that there has been some differences. There's new regulations that have been put out by the lobbying regulator, the Joint Commission on Public Ethics, and this slide will tell you pretty much what the existing practices are and what's changed. A lot of the specificity in number 2, they think that in current lobbying reports, whether you've completed them or not, a lot of people say, well, I lobby the governor, I lobby the assembly and the Senate, and they may or may not identify bills that they lobby on. They're looking for greater specificity. Why, I don't know, and whether they'll have the manpower to actually enforce it, I couldn't tell you. But there is a lot of activity here in terms of they're going to want more information about who you met with. I'm hopeful myself that it's not on a daily basis, that it's on the period, the lobbying periods are bi-monthly, so that you could say that instead of just writing that you lobbied the assembly, you may have to list some chairman's office, you may have to list Ways and Means, you may have to list Assembly Program and Council as an example with more specificity. But we don't think, because they of course have not provided the forms that you will be reporting on, I think the forms to some extent will actually inform how much detail they're actually looking for. We haven't seen that yet, so we're expecting some greater specificity. But I can't say that based on this slide that we have definitive, and there's another reference later in the presentation, exactly what it is they're looking at and at what specificity and at what frequency. The other thing, if you go down to 4 on the left-hand side, in addition to grassroots, there's more specific attention to if you have a lobby day, what you need to report based on the lobby day, and also coalitions, which we'll talk about in greater detail, because that seems to be a creation of these regulations. Calling yourself a coalition, it has specific meaning. I think that in everyday life we all act as part of coalitions, but that doesn't mean that we meet the definition of coalition for the purposes of lobbying, and we'll talk about that. So I think those are the key differences there. Who's a lobbyist? This kind of gives an example of, let's assume that you're a center and that you have employees who are, whether it's the executive director, whether it's a director of advocacy, could be someone else involved in specific tasks, who actually are employed by the advocacy center. In this case, that the center itself is the lobbyist, It's also the client is confusing. The advocacy center is a lobbyist, and there are generally places on these forms in which you would identify specific employees that are employed by the center that are lobbying on behalf of the center. So this is beyond the 5,000. This is assuming that you are registered, and this is how you would report it. On the next slide, designated. Again, this is a new phrase that they're using. I'm not sure why they got into it. Somehow they think they need to distinguish, and I'm not sure how you would accommodate for compensation, if at all, if you've got unpaid board members or directors or officers, how that's supposed to calculate itself to, does this contribute to a $5,000 threshold? But in any case, the designated lobbyist, your board members in their capacity as a board member of your center would be lobbying on behalf of the center. The last one would be someone in my situation in which NYAIL hires me to lobby on behalf of NYAIL. I'm the lobbying firm, and if I had other people working for me lobbying in the firm, as retained lobbyists, they would be identified. But the retained lobbyist is someone who's hired by another group to lobby on their behalf. Multi-party relationships. Again, new terminology, prime, sub, and co. We'll go to the next one, the reporting obligations for all parties to a lobbying activity. So the lobbyist in this instance would be a center. They would have to register through a statement of registration. They would have to file bi-monthly reports. That's not a new requirement. That is the current requirement. The disbursement of public monies doesn't apply to 501c3 corporations, so that is not applicable in our case. The contractual client. Now, generally that, unless you're hiring someone outside your agency to lobby for you, that probably won't affect you. In NYAIL's case, they are the contractual client. I would be the lobbyist for NYAIL. I would file a bi-monthly report on my NYAIL activities, and NYAIL would be required to file a semi-annual report on both their activities and what I do on their behalf. That's not different than current practice. It's just called different things. Beneficial client, I believe in existing terms, there is, they call it a third-party beneficiary. That would be an instance where if NYAIL, it should not affect you. If NYAIL hired me to lobby for them, and then I hired 2 other lobbyists to help me lobby for NYAIL with that money, the lobbyists that I hire wouldn't be lobbying for me. They would be lobbying on behalf of NYAIL. NYAIL would be the beneficial client in that particular circumstance. I think we went through this before. They put the same slide in a couple different places. We've already gone through what the direct lobbying stuff is. Okay, well, we're into coalitions now. Yep. So again, a common practice in Albany is for people who are otherwise unaffiliated legally to get together and lobby on behalf of issues. So what they're saying here is specifically a coalition is a group of otherwise unaffiliated entities who pool funds for the purposes of lobbying. A lot of lobbying activity by unaffiliated agencies don't involve the pooling of funds. Everyone just kind of on their own dime would lobby, and it would just be a joint lobbying effort. But here they're saying that if you lobby and you pool funds, you're a coalition. I think the best example here would be Medicaid Matters for our people, because it is financed by unaffiliated entities, and they put money together and fund Medicaid Matters operation, which is, for all intents and purposes, largely lobbying and advocating on behalf of those agencies on a number of issues related to Medicaid. So, the only caution here is I think you could call yourself a coalition, but if you're not someone who's unaffiliated in pooling funds, there must be another word that we can come up with to describe your advocacy effort without calling yourself a coalition. By calling yourself a coalition, what you're really doing is telling the Joint Commission, please take a look at me to see if I'm in compliance, and in instances where it's not required. The next slide is, again, if you are a coalition, the coalition has to file it. The coalition itself has to file its own lobbying report and name someone who would be responsible for the filings, either an agency or someone who's employed by that pool, through those pooled resources, and then they would have to, in their filing, also maintain a record for the Joint Commission's review of all members who exceed $5,000 in lobbying. So for everyone who technically meets the definition of what a lobbyist is, they are beneficial clients of the coalition because their investment in the coalition is creating some benefit to them, although the coalition is viewed directly as the lobbyist and not the agency. But the Joint Commission does want to know who the members of these groups are. The or to me doesn't make any sense, so we'll get back to it. I almost think it's an and, that if you're actually paying, if you're a lobbyist and you're paying money to Medicaid Matters in these instances, the Joint Commission is going to want to cross-check as to whether both Medicaid Matters is reporting that you're a member of them, and then you're reporting in your filing that you've given Medicaid Matters some money. So, but we'll see. If you look at their slide, it does say or, which would indicate that the second one wouldn't be necessary if the coalition did the filing for you. I'm not so sure that that's accurate. But again, this is the first blush of these slides, and this isn't exactly, this isn't in regulatory form. It just doesn't make the sense to me at this point that it would be an or. Again, besides the grassroots, they're talking about direct grassroots and the new regulations. So, where are we? I must have put it in the wrong thing.
Just lost it, yeah.
Yeah, we can skip over this. We already covered what direct lobbying is. Okay, so indirect lobbying. This, again, to me is a little bit of splitting hairs in that any contact with someone related to your interest in meeting with them or talking to them or lobbying them would probably of necessity involve some sort of a contact to set up a meeting and then actually having the meeting. Here they kind of split it into preliminary contacts, which I guess I understand what this means. But apparently if you have a meeting to schedule and you're not really lobbying, they're considering that it is lobbying. Why don't they just say all activities to you know, which involve in contact? In any case, I don't think there's going to be any reporting specifically for preliminary, but they do want to let you know that anything you do to set up a meeting or an interaction where lobbying would take place, that is lobbying as well as the lobbying itself. I think that's what they mean. Okay. There are some contacts with public officials that are not lobbying. So if someone would ask you to come in and provide technical information or address specific questions, since the request is by a public official and you're just answering the question, that's not lobbying. You're not urging them to take a position. Of course, it's rare that you have a meeting in which you're providing information and not advocating for that position at the same time. So, you know, I guess that this circumstance could occur, but it's generally in the context of a broader meeting. Clerical or administrative assistance. So, so if someone's at a meeting in which lobbying has taken place, even a lobby day, and people are providing purely clerical or administrative services, and they're not speaking on behalf of the agency or lobbying a public official directly, then that would not be considered lobbying. To observe for educational purposes. I think that's self-evident. You know, even in the context of the legislative process, if you had an intern or you went down to a Ways and Means Committee meeting just to observe the proceedings, you weren't going to talk to any public officials or staff. You just wanted to see what the agenda was and how they disposed of it. That would technically be lobbying. And the last one too, that scheduling a meeting in a purely administrative capacity, I have no idea what that means. So that's a little bit confusing. So there is some exception to what's lobbying and what's not. They gave you a couple examples. Now we're into lobby days. So if you're having a lobby day, you need to identify someone who's going to be reporting the stuff. You're only lobbying at that lobby day if you make direct contact or you're speaking on behalf of the organization. So that's what would be direct lobbying on a lobby day. The next slide has expenses that are reported for lobby days. So if people who are employed by centers are coming to Albany and they're being paid for their time, it's part of their work job, that is a reportable expense. Staff time planning the event from the center's perspective, either organizing volunteers, organizing clients, any other time that's spent putting the effort together at the local level to participate in a lobby day, any paid staff time is also included. Expenses for paraphernalia, and in this instance, expenses, say, for buses or vans or other things, are all reportable lobbying expenses. And remember, going back to the definition of lobbying, all of these expenses in and of themselves could add up to more than $5,000 even before staff time is considered, which is why we're thinking that in many instances some people would probably meet the definition fairly easily. Some people may spend $5,000 just to participate in a lobby day. So now we're into social media, which is not my expertise, but I think that this is fairly, if you're sending a message via social media to a public official, and again, that's not just a legislator, that's a local public official, it's a state employee, and you know that they have an account and you're sending them a message instead of by email or by written letter via social media, that is considered to be direct lobbying. Correct, and etc. So most social media that's probably topically related and sent with the intent to reach some public official through some public social media account that they have themselves is all lobbying. Next page is the expenses. I don't think this is intended to cover people on their own time as citizens and voters, but certainly if any of the issues that they're contacting and lobbying on are related to their employment, then that is a lobbying expense. And then the second paragraph talks about the types of things in terms of organizing the social media, that expenses that may be associated with the social media at the agencies, at the centers level, which would be reportable expenses and lobbying. Grassroots. Again, this is an effort to you're urging or soliciting others to deliver a message to a public official, certainly action alerts, calls to action, all of those things in which instead of lobbying the target directly, you're also encouraging others to contact that target directly. All of that is considered lobbying, and you would, in this instance, in a grassroots way. So it's the communication, grassroots communication would have to reference a specific activity, a bill, an executive order, a regulation, you'd be taking a position on that, and you would be asking people to make calls or make contacts in whatever fashion on your behalf would be the call to action. So I think the communication itself needs to be reasonably specific. It's related to something that is being lobbied. Lobbying activity here is the phrase that they use. What is a call to action? I think you can read through that. I think that's fairly straightforward, and you would understand what a call to action is. So you're asking people to either directly contact someone or contact somebody else in addition to themselves to get in touch with a public official on a lobbying matter. Organizational grassroots lobbying. Again, I think that's similar to what we've already been talking about in our instance. It's a call to action issued by a center in your instance, and when one of your employees does it at your direction. I think that's fairly straightforward. Again, there's always exceptions to the rule, so a lot of the stuff on the next slide regarding functions or roles alone. It does say alone. There may be some of those things that are used in context, with specific lobbying activities. They're just saying that just because you're a delivery service, just because you're a media outlet, a lot of this is sensitive to some of the previous regulations put out by JCOPE, had a very strong reaction by television and print media, who thought they were attempted to define all of the activity of the free press as a lobbying activity, and there was a big to-do about that. So they're trying to be specific here that people, journalists and others, as well as some of the other things, just because they're doing the job, and they may be doing their job in the state capitol, they're not necessarily lobbying. They're covering a story. They're not advocating a position. Again, we're starting to sum up here. So to sum up, they're looking to get coalitions and clients and maybe some groups that hadn't previously identified themselves or identified themselves in specific ways to report. Greater specificity on subjects lobbied. Again, this was referenced on that previous slide. We still don't know exactly what it means and to the detail that they're going to require it. The third bullet on the disclosure, that is already something that's required. I don't think that that's new, except for where it goes, or description of activity related to the intended. Again, it's a little bit confusing. I don't think that particular bullet is a new reporting requirement. The disclosure of the intended targets of the lobbying relates to the second bullet. Again, we don't really know. It's because it says the name, organization, and or, whether they want and or whether they want or whether one will satisfy instead of both or all. So it's kind of poorly written, but for people here in Albany that lobby on a daily basis, these bullets are very, very much of concern in terms of how much specificity and detail people are looking for, and it does affect the time that would need to be put into your compliance and your reporting, and whether in fact, since we barely get back our 2-month reports within the 2 months after that we filed them, whether in fact the agency itself will be able to fully, have the staff necessary to actually regulate these new. It's one thing to ask for new reporting requirements, and it's another thing to actually be able to handle them. And I think that the experience with the lobbying regulator in the past is they know what they're asking for, but they don't have any staff around to actually do the job of compliance. So In the end, why they need to know whether it's direct or grassroots, I don't know. It's all lobbying and under the definition of lobbying. But on the report, there may be some designation, as there is currently, as to whether you're lobbying, it's a procurement lobbying or a direct lobbying. Apparently now they want you to identify whether you're doing grassroots lobbying. There's some contact information for JCOPE. If you don't know where to find Lindsay, her address is on the last slide.
All right, thank you, Kevin. So as I indicated, much of this or all of this content came from a JCOPE presentation directly. They did a pretty extensive training via webcast and in person here in Albany a few months ago. If you go to JCOPE's website, the full slide deck is available there.
About 110 pages.
Yeah, 110 pages. I would say we kept 40. I would say the other 60 really weren't relevant, to NYAIL or its member centers, but certainly if you want to see the full extent of the presentation, it is available there. I think, as Kevin indicated, in preparing for this, I think it was pretty apparent to us that probably most centers in the network would meet that threshold of having to report, just by the nature of the advocacy work that we do. That's not a bad thing. It's just, unfortunately, a bit administratively tedious. There's still certainly some questions out there in terms of what that reporting is going to look like come January 1. And we're certainly willing to do an additional training session when, those reporting forms are available and we have some greater detail onto the new requirements specific to reporting. So we'll take questions now. I see we have at least one written in. If others have any, please feel free to submit them. We hesitate to unmute all the lines just because oftentimes that results in some chaos, but there is the ability to kind of raise your hand electronically too, and we can unmute individual lines. So one of the questions we have here is, do you have a form template for tracking expenses? The answer is no, at least not NYAIL does not. That's in fact something that I've been talking about internally, is the need come January 1 to really better track in an Excel spreadsheet or some form our lobbying activities and the related expenses, not knowing going into the new year what the new reporting form is going to look like. We want to be sure we have all the information available to be able to report in whatever detail it is they're looking for. Right now, at least speaking from NYAIL's perspective, our reporting is pretty general. We just list Assembly, Senate, Executive, the various state agencies in terms of the bodies lobbied. We just take a percentage of the staff time to report, and it's really pretty general, and we're not expecting that to be the case moving forward.
And even aside from expenses in terms of reportable compensation, I mean, again, that's a best judgment call almost on the part of the agency to determine what percentage of the person's job activities are related to direct lobbying, how many are there. You can extrapolate that based on salary to what the reportable lobbying compensation would be. So a lot of that stuff has always been without specific direction. Maybe that's probably the best thing, and in the best judgment and of the agency, because it can change from period to period also in terms of how much activity related to lobbying is actually taking place. So a lot of that stuff is self-reported, but if you file a report and you get audited, and everyone eventually will get audited, they're going to ask you for some justification, some written justification upon how you based your calculations.
Another question was, is it fair to say that our SAN network is involved in direct lobbying? And I think the answer is yes. Certainly some of the activities related with the SAN is, more public education oriented. But, speaking to the description of grassroots lobbying and the call to actions, I mean, certainly the action alerts that NYAIL distributes and then the SAN network takes action on and distributes at the local level would certainly constitute as a direct lobbying activity. Any other questions from anyone on the line?
Yeah, I think New York City does have its, well, I'm not sure how similar or dissimilar they are. I do think that there is New York City lobbying requirements. Certainly, there are different rules and laws in the city regarding lobbying New York City public officials. But at the state level, anything that you do that would meet the state definition of lobbying that is done with New York City officials and staff would raise the issue of needing to register at the state level in addition to the local level. So just registering at the New York City level because you lobby, you spend a lot of time with the New York City government lobbying contracts and other things, or the city council, and you don't think you do anything in Albany. Technically, even though you're operating under a similar set of rules in New York City, local lobbying is that by definition meet the state definition, and the state wants to know what that is.
The follow-up comment was just that the question as to whether the forms, if they remember correctly, are onerous, and if you don't fill them out correctly, you can be fined heavily.
I think most of the fines have to do with not filing or filing late. There's always the ability to amend reports based on improved knowledge or recollection. I think the biggest issue is for them is not filing or registering and then not submitting reports. And the frequency to which you're delinquent would raise the number. I personally don't find the existing reports to be onerous, which is why I've been expressing a little bit of concern in my presentation about what the expectations on detail in terms of what you're, whether they're looking for a daily diary of everything you do. If I spend 3 hours in the Capitol, 60 different things could be lobbying based on a number of different clients, just based on who you run into in the building. So there's lots of concern there, but I don't think the existing forms electronically, I have never found them to be, once you get the knack, and we can certainly give people some help. I don't think I don't think the existing forms are particularly onerous, but there are fines associated. If they find that you're deliberately hiding, or that you're a lobbyist and you didn't register, or you registered and you didn't report, those things come to their attention, for sure.
The next question is, as this information is clarified, is NYAIL able to follow up so we can either prepare our own record keeping or use the one that NYAIL creates? And the answer is yes, absolutely. As we've indicated previously, we're definitely waiting for some additional clarification on the greater specificity that JCOPE is looking for in its reporting forms.
It would be unfair for them to put us into a period that starts on January 1st without some knowledge of the form that we're going to have to use to report the activity that starts on January 1st. So we're hoping that we're going to get more specificity. Some of us are almost afraid to ask for it. But I do think that we're going to have some level of a better understanding than just a PowerPoint presentation.
The next question was, should we register now if we believe we'd be subject to these rules? There was actually just a memo from JCOPE distributed today regarding the new registration form being available and some direction on setting that up and creating your user profile. So I can forward that out to everyone for consideration. Certainly you can register now ahead of time. I also think you can just wait until January 1 and register at that time. Is that correct?
Yeah, it is. And in fact, for myself as an employed lobbyist, if I get a new client, I actually have 15 days after the client is engaged to register with the state. So there's no reason not to do it if you reasonably expect that you're going to. Your knowledge about what you might be lobbying on next year may not be great, but you can still, in the existing forms, you can just say not known at this time. Generally, that stuff begins to flush itself out when bills are introduced. We're not going to have a budget until the 3rd or 4th week in January, and for us and this agency, a significant amount of the lobbying activity is specifically related to the budget and the budget provisions.
And the first report for the 2019 year won't be due until March 15th because January and February is the first bi-monthly reporting period, and then you have until the 15th of the following month to report. So as Kevin indicated, we're hoping that the new reporting form is going to be available prior to January 1st so that we know how best to track our activity in those first 2 months of the reporting period, but we have not heard yet.
And we have clear expectation of the information, the component information that they're looking for.
All right, well, that seems to be it, and I think we're just under an hour now. So thank you all. We did record this presentation. We'll make it available on NYAIL's website so that those in your center or others in the network who aren't available can listen, and certainly we'll follow up with additional information as it becomes available and do additional trainings as needed. Thank you, everyone.